fixated on that. The next panel, we are very pleased to be able to introduce two individuals representing two departments that are part of the national effort of attorneys general and in some cases departments of banking to look at some of the, quote, robo-signing kinds of issues that have emerged. And in Pennsylvania, we're very pleased that both our attorney general and our banking secretary decided to join in on this effort. I'm sure all of you can understand that they're going to be limited in exactly what they can report. They can't report specifically what the results of an ongoing investigation are, but I think on the other hand, both John and David will be able to convey some very helpful, worthwhile information. So John Abel is the Senior Deputy Attorney General, and David Blyken is with the Attorney General's office, and David Blyken is the Deputy Secretary for Pennsylvania's Department of Banking. They both, in their respective departments, kind of head up that activity. I might just add, some folks may know that the Attorney General is taking on a new job soon. So we're pleased that as Attorney General, he decided that he wanted to be a part of this national strategy effort. It's exciting to see a governor coming into office with the background of having that concern about mortgage-related issues. So John and David, thank you.
Thanks, Sam, and thank you for inviting us here this morning. David and I drew straws, and because Abel comes before Blake, and I got the honor of speaking first about what's going on in this particular area. And I thought what I would do is a couple things. Talk a little bit about the way this multi-state process works in general. I think some of you are familiar with the multi-state phenomenon, what it consists of, and what our experience is with working with other states in this multi-state context. So I thought I would do that at a kind of a general level. Then I wanted to talk specifically about some of the predatory lending multi-states, what's been going on in Pennsylvania, particularly with our working with our friends at the Department of Banking, and what this process is consisting of currently on what's been referred to as the robo-signing, as sort of a catch-all, but what that process is and where we are in that process at the current time. So let me start with sort of the general and work down to the specific. We've had this multi-state process for quite a while among attorneys general. What'll typically happen is there'll be some sort of scam or problem that's crossing state lines of national import, and the thought always was that there's strength in numbers and that a lot of the states have similar UDAP laws, although they vary from state to state, but they all share a few common characteristics, namely that the state attorney general is authorized by law to seek an injunction to stop whatever practice is going on that we deem to be illegal. So we have the power of an injunction. Likewise, you could get an affirmative injunction that would direct the respondent or the party on the other side to make some sort of affirmative steps, such as better disclosures, improve their record keeping. Also, you'll have as a common characteristics in multi-states monitoring. It's not uncommon that a third party be brought on to monitor a company's practices and give regular reports to the state attorneys general. Our record-keeping requirements, we've done that before in the context of our multi-states in which the business has to maintain certain records and then make them available upon demand to the attorneys general. So that's one component part that we've seen typically in multi-states, and that's very important because a lot of times we want to stop the practice and then on a going forward basis have the company operate in a lawful manner. The injunction is helpful because it does, at least under our consumer protection law, that injunction we deem to be something we can go in for sanctions on. if we settle on a consent petition, and I don't want to digress too much on this, but if we settle on a consent petition, which would be a complaint followed by a consent petition, we then get a court order. And then if a company's not filing injunctive relief, then we get contempt, because then they're not filing the order. The other way we've settled cases are assurances of voluntary compliance. So the states have this power to seek injunctive relief in the multi-state context, as well as cost, penalties, and restitution. And the restitution formulation vary from state to state. But that's typically been the hallmark of the multi-state process in terms of the results that they're getting. They usually share those three characteristics: injunctive relief, penalties, costs. I put those together, and then restitution. That process, as you might imagine, is often like herding cats, and I like to say it's probably closer to herding mice, because you've got a lot of different states in the room or on the call that have varying ideas, maybe varying objectives. But the process, in my experience, has been, I've been doing this for about 10 years now, it usually comes out with a strong result. That's not to say there's a lot of discussion among the participants, but we've been able to achieve, I think with some level of success, some strong multi-state settlements, again, that they're strengthened numbers. And oftentimes the respondent, the other side, has an incentive to do that because they want as many states on board as possible in a multi-state process. So that's been the general overview. And that multi-state investigation would typically consist of intensive document reviews, interviews. We're looking at paper, we're talking to people. We may be consulting an expert, someone from the outside who has more expertise in the area than we do. But the result has been a couple of cases that I'm sure you're familiar with, starting with household, and then moving on to AmeriQuest, which was another multi-state settlement, and then both of which were the Pennsylvania Attorney General and Department of Banking. Those cases resulted in substantial restitution back to Pennsylvania consumers. And then more recently, the Countrywide / Bank of America multi-state settlement. So that's sort of been some of the bigger settlements on the multi-state front. Well, we were fortunate, I think, in Pennsylvania here, in that for at least 2 years now, there's been a strong working relationship with the Department of Banking, as well as PHFA and Department of State, in that we've been looking together at the loan modification scams. So I know they're still out there, and if we'd be happy to hear about those. We were able to talk to your group previously about sort of what was happening with loan modification and some of the variety of scams that have popped up. Fortunately, not a lot in Pennsylvania. A lot were in California or Florida. But the idea was help us modify your loan, drop your mortgage, and people are paying money and really not getting any kind of service at all. The reason I say it as a backdrop is probably for 2 years, we've been working together, meeting about every other month, those 4 state agencies to look at those types of operations. We've sued several of them in Pennsylvania. Department of Banking, through their administrative process, have been able to take actions against the loan modification scams that are out there. It ties into somewhat what the robo-signing issue, but the loan modification has not gone away, and now the complaints, and I'm seeing some complaints, and we'd be interested in getting these from you folks, is they're using, I've seen businesses using this robo-signing issue to almost create a new wave of a loan modification. So the come on is, listen, I'm a forensic auditor. I'd like somebody to find me what actually is a forensic audit, but it seems to be one of the term du jours. I can do a forensic audit. I can find out if your paperwork somehow violated state foreclosure laws, and I can use that to help modify your loan. So we were going to see some complaints about that, and that's, I think, is an outgrowth of the sort of the high-profile nature of this investigation that's undergoing. So that's a sort of maybe an unintended consequence, but we're starting to see that more and more of we're the experts. We can go over the paperwork and we can find out where there's a violation of a foreclosure law. So we were, as I said, I do think, as a footnote to that, the Federal Mortgage Assistance Relief Services rule Mars rule has now been adopted, and that federal rule is to go into effect either at the end of this year or early next year. My hope is, our hope is that that'll help to cut off a lot of those operations, because it essentially is a ban on advance fees in that rule. So you might want to the extent you have an interest in that area, take a look at the Mars rule. But that was a helpful backdrop for us, so that when this story initially broke, which was probably about two months ago, and you first started to see it, the robo-signing issue and related issues, it didn't take much for us to start working together with the Department of Banking to coordinate our efforts. So where are we at this point in time? Well, we got all 50 states on board. Pennsylvania had signed on board. So there really is this process by which the states regularly confer. They regularly share information. They are talking about strategy right now. They are discussing, I think, at a high level, what would be the sorts of relief or what would be the component parts of a settlement that we would be thinking about, or what's sort of like the end game. I tell you, that's a very fluid process. But obviously, we know some of the benchmarks I talked about before, which is injunction and restitution. So there's discussions about that. Obviously, nothing's been decided, nothing's been set. No one has, there's no template out there in terms of what we want to get out of this. And I think for good reason. I'm a believer you got to put the horse before the cart. So you really got to do your due diligence of the investigation first. So you've got to drill down to the paperwork, to look at the foreclosure paperwork, to see if that's consistent with state law. Pennsylvania, we know, is a judicial foreclosure state, and the rules of civil procedure that control that. You've got to look at not only the general rules of civil procedure, but the specific rules on what's required to conduct a foreclosure in Pennsylvania. So you got to drill down deeply on that to see where the facts take you, so that you would have a basis to argue there's been a pattern or practice of a violation of the law. That's really what we look for. We look, the isolated case is helpful. I mean, I think oftentimes you've got compelling facts in an isolated case that's helps in an investigation, but sort of our touchstone, so to speak, is there an established pattern or practice that could be proved in front of a court of a violation of the law. So, that's why, the way we do this is at least the way we like to do it is take it one step at a time. So let's see what the facts bear out, and then that'll get us to a point of what sort of resolution should there be to make sure that the practice doesn't happen again in the future, and also that there is an appropriate mechanism for relief. So we've got these states doing this at this rather high, high-level discussions, as well as ongoing reviews. Pennsylvania as well is conducting its own reviews, so it's not simply kind of going along with the multi-state. We're doing our own review here in Pennsylvania. We're fortunate, I think, with this particular multi-state, that we have a presence on the executive committee. And I should have mentioned that earlier. As I said, herding cats, there's a lot. You get 50 states on a call, and believe me, those calls can go on for quite a while. You get 50 lawyers on a telephone conference call, and they can cover a lot of different topics in the context of a conference call. So, by definition, there has to be some sort of leadership. So the executive committee here. Let me read you who the states are that are on the executive committee. That meet more regularly, I should say, than the large group. But that would be Arizona, California, Colorado, Connecticut, Florida, Illinois, Iowa, New York, North Carolina, Ohio, Texas, and Washington. And then we actually have Pennsylvania present through the Department of Banking, banking regulators from Maryland, New York, and Pennsylvania. We've got a total of 50 states, as I said, and then my last count was 37 banking mortgage regulators, so superintendents of banking or whatever the particular office is or department is a given state. So we've got a fairly strong presence from both the regulatory side and the law enforcement side. This is, as I said, I'm always reluctant to narrow the scope of an investigation. My typical case that I pick up off my desk, and we send out a subpoena to a company, they always want to say, well, what's this all about? What are you looking at? What do you want out of this? Let's just cut to the chase. Let's do a settlement today. Let's do an AVC today and make this all go away. And you tell me, Mr. Attorney General, what it is exactly that you're looking at, and then we'll go from there. And I think there's a reason not to do that. There's a good tactical reason, as a general rule, not to say, well, listen, we're only going to look at A, B, and C, and then that's going to be it. So if there's a D, E, F, and G out there, that's off the plate, that's off the radar. So I do think it's important not to artificially or prematurely limit the scope of what might be of the investigation. But clearly, I think it's fair to say that the group is looking at the so-called robo-signing issue, so the compliance with the state foreclosure laws. What evidence is there that they were complied or not complied with? I would say as well, Iowa, who's the lead state, has said as a public record in front of Congress that the group also intends to look at issues regarding the accuracy of the information used by servicers in the foreclosure process, and other issues such as various service-related fees, so that I wouldn't want to give anyone the impression that that there's necessarily a narrow scope to it. I think it's a very fluid process that remains to be defined as to what everything that the multi-state is going to be looking at. But as I said, I've had to force myself to become something of a not an expert, but someone who knows more about foreclosure law than I ever did know before this. Which kind of leads me to what I think the main point that I want to make here today, and I appreciate Sam's remarks. We've met with some various legal services folks several times now throughout the state, and the invitation obviously stands. I think that what's most important is that you folks know who are the people to contact on the investigation. And let me give you my contact information. It's 717-787-9707. And I'll give you my email. It's jabel@attorneygeneral.gov. Unfortunately, I can't give you a blow-by-blow of where we are, but I can tell you, when I was talking to David about being here today, I think some part was to convey to you what we can, and then also be eyes and be really a big set of ears for you folks, so that if you have maybe a strong example of where you think there's been a foreclosure that didn't follow a Pennsylvania process, and then there were repercussions from that failure. They're the types of cases that feel free to refer to us or to let us take a look at. So in a lot of ways, I'd like to think of you folks at the front line, because you're the folks that have clients coming into the office and letting you know about sort of their own particular circumstance. So in that regard, I think it's helpful that you know that we're here, and we're certainly willing to accept that kind of information. We will, as you know, from time to time, we have a mediation unit that can mediate complaints. That does become problematic after the foreclosure process has started. But if you have a client before the foreclosure that's having difficulties getting a modification, or feel like they're getting yanked around by the servicer, they're always welcome to file a consumer complaint, and we can attempt to mediate that. The mediate is a role that we play, as I'm sure you're familiar with, that we try to resolve the case. We don't act as a fact finder or a judge, or don't have any power to compel a resolution, but it is a place for some consumers to go that we will attempt to get it resolved on their behalf. Can't guarantee that. And that number, as you might already know, throughout the state is 1-800-441-2555. So that process is open there. In any other type of case, if you got a loan modification scam that you're having problems with, please feel free to file the complaint. We may not get that resolved ideally to the consumer satisfaction. Sometimes we do. I'll be honest with you. Sometimes we don't. But they're helpful because, again, those complaints help to develop the pattern or practice that's essential for us, which is sort of the touchstone for us when we go forward as appropriate with a legal action. So that's pretty much what I had. I hope I didn't steal all your thunder, David, but turn it over to Mr. Blake.
Good morning. I run the half of the banking department that does the non-depositories, so the mortgage companies, mortgage brokers, mortgage lenders, check cashers, money transmitters, car dealers, and they do dealer financing, that kind of thing. So I'm the non-bank regulator. I'd like to echo what John said at the beginning. Our partnership with the AG's office and PHFA and state in the loan mod process, it's the way government ought to work. Doesn't usually work that way, but it's been a remarkably productive partnership, and it's been very good with consumer protection. And it really made it a very smooth transition into this robo-signing stuff. Let me tell you what Pennsylvania, our half of the partnership is doing, as well as what my peers, my colleagues in the other states are doing. So, as John mentioned, all 50 AGs have signed on to looking into and investigating robo-signing, as well as most of my colleagues in the other states. There's a task force, or whatever you call it, and we work jointly together to look into this stuff. So what does that look like? Right now, it's a bunch of conference calls. There's tons and tons of conference calls between the states to talk about what we're thinking, what we're hearing, conference calls with people who have things to say. Servicers attend these conference calls to pitch us what their side of the story is, and other folks. So that right now is sort of the main way that the collaboration is working. There's also some meetings, in-person meetings, and I understand there'll be even more in-person meetings. So that's what the coalition looks like today. Now, let me tell you what we did in the last couple months. As John said, a couple months ago, this issue, this robo-signing business, hit our desks. One of the first things that we did, John and I, was reach out to you folks. We reached out to the housing counselors that we knew and the legal aid folks that we knew. And we're very pleased at the amount of assistance we got. You have to understand, we've been focused in the last several years on mortgage issues for sure. We spent a lot of time on mortgage fraud at the origination side. We both handle complaints on the servicing side, but our enforcement efforts had been on the front end of things. That shifted when we went to loan mods, but servicing is not where we have spent most of our time. So getting smart quickly on the issues that people were seeing in the servicing side, not just the robo-signing, was key. And the way we did that, and this was unbelievably helpful, was through Sam Milkus and the umbrella organization and the individual organizations, especially in places like Philly and Pittsburgh. But to the point where folks, Sam got together a bunch of folks. They did a lot of legal research in a short amount of time, brought to us cases that would drive our thinking, and met with them in Harrisburg in our offices, and sat down and got a tutorial, literally, for hours, on what the issues were that you folks see on a regular basis on the servicing side and the foreclosure world. That was unbelievably helpful. We had our folks there. My boss, the Secretary of Banking, was there. We took lots of notes. We took the materials with us. And we literally took those cases and built examination procedures around them. We said, okay, well, here's the issue. 10 issues. How do we do that? How do we look for that? Same with some of our housing counseling friends, folks out in the world who deal with the counseling side, similar types of contact. So it has been an incredibly fruitful connection for us. And we saw that also in the loan mod process. When we were looking for people of interest, targets for our attention, one of the things went to Bob Bobanchek and Terry Redmond. And they reached out to housing counselors and said, okay, Who do you know about? Who should you be focusing on? 2 weeks later, got a long list of people to start looking at. Unbelievably helpful. So that's been a very fruitful connection for us, and we appreciate it. So we also spent some time reading these articles. If you plugged into the, how emails go around, there are several key articles that we looked at to understand the scholarship behind the issues related to servicing incentives, NCLC, CRL. There's a lady in Iowa, I think the Porter article is very helpful. So there's a lot of scholarship out there that has also informed our thinking and our review and our examination of this problem. So let me talk about that. So that's the prep. We reached out to folks in your world. What did we do? The state financial regulators, Pennsylvania Department of Banking, New Jersey Department of Banking, Insurance, all that stuff. We actually have a system that we didn't have, say, even a few years ago. There's a committee. Every state financial regulator signed on to an agreement. It's formed a committee of 10 states. Interestingly enough, the chair of that committee right now is Don DeBastiani, who is one of my folks. So Pennsylvania chairs this committee. And this committee has taken on the task of assembling state financial regulatory resources to examine the servicers under our jurisdiction for this issue. So we have right now 8 major servicing examinations. So how does that work? There are 8 lead states. Pennsylvania is a lead state on one of them, and there are 7, or actually 8 others, 2 are joint. So there are 9 states leading 8 exams. And then other states climb onto that exam as a joint state. And they all do file review. The lead state does a larger sample of loans, 100 to 200 loans to review, plus things like internal controls and the larger set of management stuff. What is management doing? So that's what's going on right now. So in 2 weeks, the state regulatory apparatus has stood up 8 major exams, and that's big for us. That's a lot. And we've all exchanged our exam materials. So the stuff that came from our conversations with the legal aid attorneys and the housing counselors went into our exam protocols, which were shared with all the other ones. And we took stuff, especially from North Carolina, New York, and Maryland, and we sort of put them together with an understanding. So the nationwide state regulatory effort has been directly influenced by the folks in this room, and that's powerful. So there are 8 major exams. What are we looking at? Well, of course, there's this robo-signing stuff. And by robo-signing, just to be clear on our terms, this idea that the servicer has en masse executed affidavits or other documents under oath without the personal knowledge, information, or belief necessary. It depends, and one of the things we learned, it depends on which document you're talking about. Is it personal knowledge, or is it knowledge, information, or belief? And that was incredibly helpful, too. Okay. So we're obviously looking at that issue. And that isn't as, some folks have admitted that they have issues, some servicers have not. So that's up. But if you think about that, right, that is a symptom of a greater problem, right? If you are treating these issues, legal compliance, with that level of noncompliance, where else do you see that? What does it lead to, right? The other issue for us, of course, is consumer harm. You have to answer the so what question. You can levy massive penalties for violations of law en masse, and that's important. Disregarding the law systematically is not okay. But if there's consumer harm attached to what's happening, then obviously that's what we care about. So we're not only looking at robo-signing, but we're looking at consumer harm on the servicing platform in general. Again, informed by our discussions with folks in this room and others. What happens when they board the loan? Is it accurate? Are the interest rates calculated correctly? Are the fees correct? Are foreclosures precipitated by mistakes on the servicer part? It would appear that there are some adjudicated cases out there today in the Commonwealth that would answer that question in the affirmative. But the question is, all right, is that a system? Do they do that all the time? So we built exams to look for mistakes in the servicing platform, and in particular, did they precipitate a foreclosure? We're very concerned about that. Also, we are going to look at the concerns about loan mods versus foreclosures. There are in many apparently servicing platforms 2 parallel tracks. And the concern we have heard is that foreclosure seems to win that race a lot more than the loan mod side. So we've built that into our examination procedures. We are trying to look at the issue of incentives. Are people incentivized to foreclose more than they are incentivized to modify? And that's a complex problem. But we have some good folks who are crunching some numbers on that, and we hope to be able to answer that question. Internal controls, a very bland regulatory term used to define, attach itself to the idea that are they in control of themselves? It sounds like an odd question to ask, but these companies are so enormous sometimes that there are disconnects between senior management and front line, and obviously there are disconnects between the law and implementation. As simple as that, and we're conducting a very strong internal controls review. So how are we doing this? We obviously have examiners, people who are trained to look through not only mortgage files, but also to look through corporate structures and look at accountability issues. We have also deployed our investigation division throughout the Commonwealth. We sampled consumers, we knock on their doors, we show up at night, we take their statements and to see if they have experienced consumer harm or other irregularities on the platform. Our consumer services division, we have folks who answer the phone and talk to consumers. We've done a top-to-bottom review of our consumer complaints, as has the AG. Those are obviously gold mines, supplemented by the complaints that have been brought to us by you folks and others. Very, very helpful. In our compliance division, obviously, we're pulling people out of cubes. This is an enormous effort, and we redeployed resources from cubes into the field to attack this issue. It's fair to say that there's a lot of grist for the mill. It's just what John said. We need the facts first. We intend to gather the facts professionally, fairly. It's very important to understand that we're in the business of being fair. We don't go in predisposed. Of course, if people made public statements, we will take that into account. But we will come in with a blank slate, gather the evidence professionally, and draw conclusions. Interestingly, though, it's fair also to say that if you're reading the newspapers, that you can see that folks, including General Miller himself, have talked openly about the challenges with the loan modification process. Right? So we're conducting 8 major servicing exams. The federal apparatus and federal regulators and others are also conducting their reviews. And I will say this, the state regulators have typically, we always complain about not getting enough cooperation from federal apparatus, federal agencies. In this case, we've seen a lot of cooperation from the federal side. They're very focused on this issue, and we really appreciate that. But I think that you will certainly see the discussion at the end of all these examinations and investigations. You will see a meaningful discussion and debate about loan modifications and how to solve a problem that has yet to be solved. So that's what I have to offer. And John,
I think that's very good, David. As I said, I think it bears repeating that there's been no conclusions, no determinations made. We'll go where the evidence leads us.
And we'll take questions?
Yeah, we're happy to take questions, or if you think there's something that we ought to know about, or a nuance or a twist of this issue, I'd love to hear about it.
I know we really appreciate your being here and taking an interest in these problems that affect all our clients. It's really great to have the state feel like you're on our side, or see actual evidence that you are. I know that legal aid advocates have talked with both John and the two of you, John and David, and you did mention talking to housing counselors. I just want to say that that they have a vast amount of information. They're really on the front lines, and we've heard stories this morning about servicers or lenders telling people not to apply for HEMAP, and about homeowners going to the servicers telling homeowners that when they come to apply for HAMP, the federal mortgage modification program, that they should stop paying their mortgage. And people who walk in current on their mortgage and eventually are turned down for HAMP end up being in a big hole. So if you haven't heard those stories, I encourage you to talk to housing counselors some more and get that kind of information that they have.
Thank you, that's helpful. Other questions or comments? We really love to hear from you.
Yeah, I have a question. I was not able to make the meeting in Harrisburg, but was on the phone call for the meeting with the banking secretary. And one of the questions we have, and we have been raising this with our local district attorney in Philadelphia, and that is the pursuit of criminal action against servicers and even lawyers who have been involved in the robo-signing and clearly fraudulent activity, not only at the lower level, but also at the higher level with servicers who obviously knew about, maybe even set these practices up of putting someone in a room and having them sign 400 affidavits a day. And I guess the question is, and I would hope the answer is, that that's something that you're pursuing not only from the civil end, but also the criminal end.
Well, that came up in the context of our meeting, and obviously, you know, the way I answer that question, because I have to be careful the way I answer that question. I'm a BCP lawyer, so I can only speak to what the Bureau of Consumer Protection is looking at from the civil arena. I will tell you, you know, my generic answer to that question, and when somebody says this ought to be criminal, is to do just what you're doing, which is consult with your local district attorney. And I think that's really all that I want to say about that. I mean, I can tell you, I mean, I'm a consumer protection guy. I wear a civil law attorney's hat, and that's where I am looking.
Yeah, and you know, we're obviously the state regulatory authority, so we don't have criminal jurisdiction. I would, however, be amazed if at the end of this day, something like that, I don't know, but, you know, you're talking about, your point is corporate level accountability as opposed to the frontline person. I would be amazed at some point if criminal charges didn't net out of it, but like John said, we have to be careful because there's a very strong line between civil administrative stuff and the criminal side. But
I'm glad you raised it.
With regards to filing a complaint with the banking Department of Banking in terms of with modifications and things like that, what's a typical kind of case in which, you know, we should be advising someone to proceed filing a complaint? So,
well, and you can do it with us and also with the AG because we partner in these things. But, you know, it's as simple as, hey, somebody approached me or I responded to an email or whatever. I asked them for help to modify my loan. I sent them $1,000 and I never heard from them. It's in every iteration of that problem. Now, where we do it is we've interpreted our statute with the new amendments for loan originator licensing. You need a license to do loan mods because we consider it part of the origination. And to get a license, it's very difficult. I don't think we've ever actually licensed anybody who does loan mods, but it gives us jurisdiction to give them a cease and desist order right off the bat. Because not only nowadays you need a bond, you need to do education testing, there's a whole boatload of stuff you got to do. So anytime someone is between them and their modification, unless it's the servicer themselves, you need a license from my agency. And if you have a license from our agency, we've issued guidance on what we expect our folks to do. And there's also some very strong guidance for our licensees to sort of, you know, that's a very high-end contact. That really should be done by a housing counselor. That's what.
Right. What about in terms of like working with modifications with the servicer or with the lender, where they're, you know, kind of quote unquote jerking the client around?
Oh, the servicer.
Yeah.
Yeah. Oh, well, I mean, so the issue is jurisdiction for us. Right? If we have jurisdiction, call us. I'm sorry, I misinterpreted quite a bit.
No,
Yeah.
I
You're
wanted
shifting.
to
That's
know
good.
both of them.
Yeah. So you can, if we have jurisdiction, we will work with you, and we have escalation contacts. So there, you know, if you guys are being tortured by the person on the front end, there's a person somewhere above that person that we can go to, and we even have contacts at some of the national banks. So call 1-800-PA-BANKS, and basically we can tell you if we can help you or not. Otherwise, we can give you the referral number for the regulator for that servicer, but we're glad to give it a shot.
Yeah, and the same thing can happen on our side, www.attorneygeneral.gov, and that's an online, but I would say, that I think that practically speaking, it's always helpful to have supporting documentation. So to the extent that you could have help your client do the narrative, the chronological sequence of events, kind of trying to leave out the extraneous matters. But if there's a log of phone calls, and in particular, if there's any evidence or written evidence that you believe would establish that there was a done deal, you know, that they agreed to a model on this date at these terms as evidenced by this, that I think would be helpful to include in your consumer complaint. And then that could be a variety of documents that may exist.
We've got to wrap up.
Yeah, we-
But John and David, thank you very much for being here and for encouraging all of us to come to you with these issues.
Thank you.